Hello folks, welcome to Lexi IAS Academy. In this video, we'll be discussing a current affair topic. Now, the speciality of this is a current affair compilation of August month, specifically only from prelims perspective. So the topics we will see and discuss will also be from prelims perspective, and we will see the topic, that is, we'll learn about the topic based on your question and answer format. Alright, let's get into the video. The topics that we will be discussing in this video is sub-classification of scheduled caste, centrally sponsored scheme, citizen participation towards good governance, lateral entry in civil services, surrogate advertisements, and at last we will be looking into your uniform civil code. This video is presented to you by your faculty, Sushma KP. Let's get into the first topic, sub-classification of scheduled castes. First and foremost, understand few things. Why do you need classification of castes? That will be the first question. Let's take it like this. We have something called as SC, ST, OBC. Yes? You all know your Mandal Commission. After Mandal Commission report, the government decided that they will give 27% of reservation for your OBCs in your educational and employment activities. Yes, as and when it progressed, coming to your Indira Sawhney versus Union of India case, further onwards, what happened was, your court was of the opinion of create a classification within the OBCs. That is, create a sub-classification within the OBC. Right now we are speaking about your OBCs or other backward classes, wherein they distinguished between creamy and non-creamy. They found out that within the OBCs itself, there are certain section of people who are well educated, well employed, and economically also doing very well. Socially also they are forward. They do not need reservations. Understanding? So they will be put under creamy layer and they will be not given the benefit of the reservation, but rather this will go towards the section which is more deserving, that is, which is wanting it first. That is, a weaker section within a community will be benefited first. The whole point of reservation is it is not a permanent concept. It is a temporary concept. Again, what is it? It is to provide a level playing field to everyone. So this way serves the purpose. This concept is called as sub-classification. Now this is done only for your OBC. The panelists are now speaking that we should also think of considering for scheduled castes. As of now, understand one thing. There is no such sub-classification for scheduled castes. Understanding, it is there only for your OBCs. But there is, we'll take one example. For example, in your Telangana, in scheduled caste itself, let's take two communities. Malas and Madigas. Both of them are from your scheduled caste only. But if you see, this section is more dominant or predominant compared to your Madigas. So these people are claiming that they are getting benefits higher and we are not getting benefits. That is, when they are telling that, they are telling, let's say 10% of seats, right, for scheduled caste. Just an example. This section is predominantly getting more advantage over us, is what they are claiming. So, in your state of Punjab and others versus Davinder Singh and other cases, and according to your sub-classification of scheduled caste is permissible, is what at least they've went ahead to even speak about. But then again, the Supreme Court was of the verdict, according to your Article 341, where your president alongside your governor will publish the list. Now, for addition or inclusion of your caste or subcaste into your scheduled caste, that can be only done by your Article 342 and only by your parliament through a law, where they have held that no sub-classification leads to violation. So that is not right, is what certain sections are claiming. among the expert committees and among the Supreme Court judges also. So this is still a very much debated topic. Understanding? Look at this. Article 14, Article 15 of 4, Article 16 of 1, Article 16 of 4, Article 341 of 1, Article 341 of 2. All of this speaks about, basically in simple one-line gesture, if you have to understand, the whole point of reservation is just this: bringing everyone on the same level playing field. Understanding? And also Supreme Court still reiterates its statement, and again the same thing with respect to constitution also. The whole point of reservation is temporary, to bring people into the same level playing field. Now when I keep using this word level playing field, it is that within that community itself there will be certain sections which are advanced, whereas compared to the other section which are not. Now the now the priority should not be in giving blanket reservation, but to address the section in that community which needs it first, or that is where you bring in the concept of weaker first. That is, within the community itself, who deserves it most should be getting it first compared to the entire blanket reservation, is what the issue is about. See, with regard to your E.V. Chinnaya versus State of Andhra Pradesh, Supreme Court held that subclassification of Supreme Courts amounted to tinkering with presidential list and therefore was violative of Article 341 of 2, wherein adding additions or removal to the list is exclusive power of parliament where it legislates through its laws. Look at this. Jarnail Singh versus Lakshmi Narayan Gupta in 2018. Supreme Court opinion that application of creamy layer concept to Article 341 and 342 does not tinker with the presidential list. So this is the ongoing debate with regarding to your subclassification of your scheduled castes. Again, they have to focus on substantive equality, that is your weaker first approach within the community itself, whatever community, be it OBC, SC, ST, you will find the section which is weaker first or which is not having substantial, look at this word, they are not having substantial equality compared to the same members in that same community, just different, let's say, like we spoken with respect to your Telangana, Malas, Matigas. So this should focus on weakest first scenario. Let's look at some questions with regard to this topic. What is the rationale behind the demand for subclassification of scheduled caste? To provide more benefits to the creamy layer, to address the intra-caste disparities and ensure equitable distribution of benefits, to abolish the caste system, to increase the quotas for SCs. Again, provide more benefits to creamy layer. The whole point of creamy layer is you provide them no benefits. So this is wrong. To abolish caste system, no, there would not be such thing where you will bring in something to abolish the caste system. To increase the quotas for SCs, no, this is not it. The answer is to address the intra-caste disparities and ensure equitable distribution of benefits. Here the keyword I want you to underline is intra-caste disparities. To address that, they are looking for subclassification. Next question, consider the following organizations or bodies within India: the National Commission for Backward Class, National Human Rights Commission, National Law Commission, National Consumer Disputes Redressal Commission. How many of the above are constitutional bodies? Answer is the National Commission for Backward Class, which is A1 only. Understanding? Rest are non-constitutional bodies. What is the term used to describe the most backward among the scheduled castes? Ati Dalit, Dalit, Harijan, scheduled caste. The answer is Ati Dalits. That is most backward among the scheduled castes. These are all necessary for addressing your intra-caste disparities, like we spoke in the previous question. What is the main criticism of the sub-classification of scheduled castes? It creates divisions within the SC community. It is unconstitutional. It benefits the creamy layer. It is not necessary. The answer is it creates division within the SC community. Okay. And one more thing, what they at least experts have pointed out, is just by doing this, we cannot assume that it is going to be an equitable distribution. So that also we have to consider. Which article of the Indian Constitution allows for the classification of scheduled castes? Article 341, 342, 1604, 14. The answer is Article 341. The next topic that we will be looking into is your centrally sponsored scheme or CSS. With regard to your schemes coming from your center, there are two types. Centrally sponsored scheme, central sector scheme. Look at this. Centrally sponsored scheme, centrally sector scheme. Now, whenever we say central sector scheme, it is 100% funded by the central government. Central sponsored scheme means where it is a division among your both center as well as state. Understanding? As of now, we have 676 centrally sponsored schemes. According to 14th Finance Commission onwards, where they abolished the concept of plan and non-plan expenditures. One of the ways where the money is given from your center to state is through these two only. Earlier there was plan and non-plan. With your 14th Finance Commission onwards, abolition of this or discontinuation of this, we started the direct source or one of the main sources of money between your center and state comes from your central sponsored and central sector schemes. All right. Now we will be seeing about your central sector and central sponsored schemes. But we will see that through your set of questions. Okay. What is the primary difference between a central sector scheme and central sponsored scheme? A, funding pattern. B, implementation agency. C, beneficiary identification. And D, scheme duration. The answer is A, funding pattern. That is one of the main difference between a central sector schemes and centrally sponsored schemes. See, nowadays, especially one of the disadvantages if you have to know about these schemes is, let's say, central sector schemes or central sponsored schemes, it is increasing the burden of the central government. And second thing is there are multiple subsets within the scheme which is creating a duplication. That is the effects what it is supposed to do, it is being done by some other scheme. Again, for that some other money is been allocated. So basically duplication of entries are there. The money is not well spent. At the same point of time, the target that you want to reach is also not being reached. So this is creating more of a burden on the government. And if you see, like I mentioned, this is an equal participation between center and states. With the states also, there is a non-willingness in one thing, and second thing is they're not able to equally put in that much amount of committed amount. So all the addresses are making it either the schemes are having funding issues because the states are not contributing entirely their part. And second thing, duplicity of entries, that is more than one scheme is there to do the same thing, and again different amount of funds are getting allocated. So because of this issue, this topic has come into news. What is the main objective of the central sector scheme of National Career Service? To provide employment opportunities to youth, to provide training and skill development programs, to provide career counseling and guidance, to provide financial assistance to entrepreneurs. So, two things you have to understand about this question. Your National Career Service, what is it? You have to know. Second thing is, it is a central sector scheme. Understanding? The answer is to provide career counseling and guidance. Which ministry is responsible for implementing the central sector scheme of Rashtriya Uchchata Shiksha Abhiyan? Again, two things. Rashtriya Uchchata Shiksha Abhiyan is a central sector scheme and the implementing agency is Ministry of Education. Time and again people tend to pick Ministry of HRD, but it is not HRD, it is Education. What is the funding pattern of central sector schemes? 50% by central government, 50% by state government, 100% by central government, 75% by central government, 25% by state government, 60% by central government and 40% by state government. The answer is 100% central government. This is for your central sector scheme, like we discussed. Which of the following is the benefit of central sector schemes? So we're seeing what are the benefit of central sector schemes. Increased state government autonomy, reduced financial burden on state governments, improved implementation efficiency, enhanced community participation. These two you cannot guarantee. The improved implementation efficiency and enhanced community participation. It has no role in whatsoever who funds the scheme. But rather what it does is it reduces financial burden on the state governments. Understanding? This is the answer for this question. The next topic that we will be looking into is your citizen participation, or we will be more specifically looking into your MyGov platform. Look at this. As of presently, this scheme was started somewhere around year 2014. It almost has completed a decade. 4.72 crore registered users are there in your MyGov platform, or otherwise they are called as your MyGov Satis. One of the main things that they bought this concept of MyGov platform is to have citizen-centric governance, and it should be citizen-friendly, include their voice, opinions through your medium of quizzes, polls, necessitate a debate, and use all of this for policy formulation. Such so held policy formulation will now be very holistic one, where a debate has been happened not just in your legislative assembly or among your executives, but also among the common people to whom the policy is for. Next, we will see about your MyGov campaigns, life campaign, stay safe online to bring awareness in the online medium, Swachh Bharat Survekshan for a healthy, clean India, millet superfood so as to avoid lifestyle diseases. Understanding? So these are all the campaigns brought in by your MyGov platform. What is the three main pillars, if you would consider, of your MyGov platform? That is do, discuss, disseminate. Understanding? We will see more of this through your questions. Which of the following is a key feature of MyGov? It is online payment gateway, social media integration, crowdsourcing of ideas and suggestions, online application for government job. If there is one keyword I want you to remember with regard to your MyGov, that is this: crowdsourcing of ideas. This is one of the key features of your MyGov platform. So the answer is C. What is MyGov and when was it launched? A citizen engagement platform launched in 2014, government to government portal launched in 2015, public-private partnership launched in 2016, digital payment platform launched in 2017. This we have discussed. It is a citizen engagement platform launched in 2014. What is the main objective of MyGov? To promote digital literacy among citizens, to provide a platform for citizen engagement and participation, to enhance the efficiency of government services, to promote transparency and accountability in governance. The answer is to provide a platform for citizen engagement and participation. The answer is B. Which ministry is responsible for the management and maintenance of MyGov? Ministry of Electronics and Information Technology, Ministry of Personal Public Grievances and Pensions, Ministry of IB, Ministry of Communications. The correct answer is it is MeitY, that is Ministry of Electronics and your Information Technology. What is the name of the initiative launched by MyGov to promote volunteerism and community service? MyGov Volunteer, National Volunteer Scheme, Community Service Initiative, India Volunteers. Answer is MyGov Volunteer. Next question. Which of the following is a benefit of MyGov platforms? Increased transparency and accountability in governance, improved citizen engagement and participation, enhanced efficiency of government services, all of the above. The reason I've given all these options is just so that you can pick all of these options. So I can give more content in form of a question. The answer is D, all of the above. Okay. How does my government facilitate citizen engagement? Through online discussion and forums, through crowdsourcing of ideas, through online surveys and polls. Again, answer is all of the above. The reason I tend to pick all of the above in same kind of questions is so I can deliver more content in the form of your MCQs. What is the significance of MyGov in the context of good governance? It promotes transparency and accountability. It enhances citizen participation and engagement. It improves the efficiency of government services. All of the above. The answer here is not all of the above. It enhances citizen participation and engagement. Just now I tricked you. I told all of the above, so you assume this also will be all of the above. Okay, the next topic that we will be discussing is your lateral entry into civil services. First, we'll understand the concept of what is lateral entry, which countries follow it. For example, your countries such as your USA, UK, Australia, these countries follow your hiring through both your direct entry as well as lateral entry. Again, lateral entry means you are trying to bring in expertise into the government at a higher level posts. For this, again, you will conduct one examination. You will select them based on your merit based. Okay, so multiple things will be there here. Now, why did the issue come in here, or why this question has come in? That is because the union government, the central government, announced 45 lateral entry posts for secretary and joint secretary, and then because of the criticism faced, they pulled out the application. Question is why? Why did they pull out the application? First, understand lateral entry means, yes, now simple example will explain. I'll be working in, let's say, IT. After a particular years, I have gained sufficient significant knowledge on this particular topics. I have good expertise. Okay, so with regard to the Ministry of IT, they feel that okay, the knowledge and skill set that I have developed over, and I have wide experience, good background, etc. So they feel that yes, this person for a temporary basis or a contractual basis, temporary or contractual, let's say from 2 to 5 years, this person, we can take this person into the job. Again, because I am already established in my field, you can't put me at entry level jobs in the government also. So somewhere let's say to level of secretary. Yeah, so I'm not telling that I'm an IT person, I'll be put at the secretary. I'm just trying to give an example as to I am working in a private enterprise, but I have good backing expertise all in my field, and I want to bring that expertise into the government. So I'm trying to bring this person into the government ambit. That is your lateral entry in civil services, or otherwise your bureaucracy. But constantly, this has been a huge topic of debate and discussion, where they feel that no, civil servants are already there in this, and then why do you want to put these people? Now, these people have spent so many years trying to build a career out of it. When did this concept of lateral entry first start in India? See, this idea was first mooted. The concept of lateral entry was very first time mooted in your first ARC report. Then your second ARC report also spoke about this. Next, your Baswan committee also spoke on lateral entry. Then again, Shashi Tharoor committee, that is a okay, he also spoke about bringing in the concept of a lateral entry. So finally, by 2018, government accepted the concept of lateral entry. Yes. Now we'll bring back yes 45 lateral entry posts they given for the post of secretary and your joint secretary. And why did they pull out? They pulled out the notification. Why? Because it drew criticism that at no point of time in the entry, that is in the notification, there was no provision for reservation for SC, ST and OBC. This was the criticism it drew. Time and again, if you see, lateral entry has been always trying to escape your reservation. It was a lateral entry versus reservation. It has always somehow tried to escape reservation. How it has tried to do that, and is it permissible is what we will be seeing. In your Akhilesh Kumar Singh versus Ram Dhawan and others, Supreme Court held that if it is, let's say the posts that you're going to give to the government notification, if it is more than 3 vacancy, okay, if it is more than 3 vacancies for a post means, then you can give reservation. So the basic thing is at least minimum 3 vacancies should be there of that particular job. Then you can consider about giving reservation. Otherwise, you don't have to give reservation. Is what your Supreme Court held. Fine, okay. But now we saw it was 45 posts. So it qualifies under this, right? That is, it is more than 3 vacancies and reservation should be given, yes or no? But with respect to reservation, the way that we are giving, we follow something called as 13-point rooster, wherein among this 45 seats, vacancies that was coming in, 6 seats should have been given for your SC candidates, 3 for your ST candidates, 12 for OBC candidates, and 4 for your EWS candidates. This should have been done. But this was not done. But again, despite the fact that it was not done, it was not violative. It was not wrong. How? See, the 45 posts that I mentioned, these are all not see, the 45 posts that I mentioned, these are all not of one particular job. This is a culmination of all the jobs in various ministries and departments. So if you look at it, it is 45 individual jobs. So at that point of time, they are coming less than 3 vacancies because it is only one. Each department they only one. So in that way, if you take, then you don't have to give reservation. So they did not violate it, neither was it wrong. This is with regard to your lateral entry and your reservations. Okay. Let's look at some of the questions. What is lateral entry and in which year was it introduced in India? It is a recruitment process for government jobs introduced in 2018. Training program for bureaucrats introduced in 2015. Policy for hiring experts from private sector introduced in 2019. Scheme for promoting transparency in governance introduced in 2017. We discussed this question. The answer is recruitment process for government jobs introduced in 2018. Just take a look at this. If you want, take a screenshot of it or write it down somewhere. This was where your idea of lateral entry, how it evolved. Okay. Next question. Which of the following is a key objective of lateral entry? To fill vacancies in government departments, to bring in expertise from the private sector, to reduce the workload of existing bureaucrats, to increase the representation of the marginalized group. The correct answer is to bring in the expertise from the private sector. This is the whole objective of your lateral entry. Which ministry is responsible for implementation of lateral entry scheme? Ministry of Personnel, Public Grievances and Pensions, Ministry of HRD, Ministry of Finance, Ministry of Home Affairs. The answer is Ministry of Personnel, Public Grievances and Pensions. Which of the following is a benefit of lateral entry? It brings in fresh perspective and expertise from outside the government. It reduces the time and cost associated with traditional recruitment process. It increases the representation of marginalized groups in the government. All of the above. The answer is it brings in fresh perspective and expertise from outside the government. Which of the following is a challenge associated with the lateral entry? Integrating lateral entrants into the existing bureaucratic culture, ensuring that lateral entrants have the necessary skills and expertise, managing the potential disruption of the existing power dynamics, the all of the above. Here, all of this are a possibility. The answer is the all of the above. Okay. Next question. What is the significance of lateral entry in the context of administrative reforms? It promotes transparency and accountability in the governance. It enhances efficiency and effectiveness of government departments. It increases the representation of marginalized groups in government. It brings in fresh perspective and expertise from government in the department. This question in different ways it can be asked. That is why I have bought in this, especially when people would pick A. Okay, this is not the objective of this. Notice it brings in fresh perspectives and expertise from outside the government is the answer. The next topic that we will be discussing is surrogate advertisements. What is this surrogate advertisements? Simple words pair. I have, assume it, I have a liquor business, but I cannot advertise it in your public medium because again, so your public health, all the concerns, etc. are there. This will be very much bad for your impressionable minds. People, your consumers will feel like, acha, it is a very harmless advertisement. If I use that also, nothing will happen. So what I do is, I will decide I will put an advertisement to promote my liquor business. But if you see in India, there is a ban. That is, you cannot advertise for your liquor, alcohol, cigarettes, tobacco. Okay. So what I do is, I find a surrogate, that is an alternate way. I find an alternate way to endorse my product. How? For example, I will showcase a model who will be promoting a product. That product bottle resembles the shape of an alcohol, and the glass that she will be holding will be of some liquid, but it is juice. In a way, I am suggesting it is alcohol, but I am not showcasing alcohol. So it is very suggestive. That is, I am hiding behind the scenes and showing. Basically, my message is reaching out to the people who I want to reach out. Why? How I'm able to try to do this? Using legal loopholes. Understanding? This is the concept of your surrogate advertisements. Recently, our Ministry of Health and Family Welfare has asked Sports Authority of India and BCCI to make sure that to prevent surrogate advertisements with regard to your tobacco and alcohol by your sports person, wherein most of the times, because of this legality, they try to still do the advertisements in the form of using your legal loopholes, like we mentioned, trying to promote the juice, yeah, and some places where the shape of the bottle itself is resembling their liquor bottles. So in which legal provisions that we are able to tell that yes, there is a ban on promotion of these things in the form of advertisements? It is Cable Television Networks Act of 1995, Cable Television Rules 1994, Cigarettes and Other Tobacco Products Act of 2003. And also if you see, especially during your IPL period of time, almost 16% of the ads are your surrogate ads, which speaks about your tobacco industry, wherein you tend to quote it for by telling it is silver coated cardamoms, silver coated areca nuts. So you try to put it in a suggestive way, but in a form that the message is out and loud clear, but without actually showcasing the content. Look at this with respect to your United Breweries Limited versus Mumbai Grahak Panchayat. Misleading claims and surrogate advertisements of alcohol were proved and discontinued with corrective advertisements. This TV Today Network versus Union of India case 2021, advertisement of club soda resembling the bottle of alcohol of the company was seen as surrogate advertisement, and the brand was asked to broadcast an apology. You see the examples of how they will try to do surrogate advertisements, that is, send the message out there, but at the same point of time, you also prove that you have not violated the law. How? Legal loopholes. We'll look at some of the questions. What are surrogate advertisements? Advertisements that promote a product or service directly. Advertisements that promote a product or service indirectly. Advertisements that are banned by the government. Advertisements that are exempt from the taxation. The main thing is between A and B. Surrogate advertisement means it is indirectly, not directly. Then if it is directly, then why do you have to call it surrogate advertisements? Right? So the answer is B. Which of the following is an example for surrogate advertisement? This I'm giving just so that you can get an idea. An advertisement for a liquor brand that shows a model holding a glass of juice. An advertisement for a tobacco product that shows a model smoking. An advertisement for a pharmaceutical product that shows a doctor recommending the product. An advertisement for a food product that shows a celebrity endorsing the product. Apart from the first one, rest all three are showing actual depictions. The first one is showing indirect depiction. So this is your surrogate advertisement. Understanding? What is the main objective of surrogate advertisement? To promote a product or service directly, to circumvent the ban on advertisement certain products or services, to increase brand awareness, to provide information to consumers about a product. The answer is to circumvent the ban, that is, navigate through the ban and yet somehow make it look like you haven't violated the rules. Which of the following laws regulates surrogate advertisements in India? Cable Network Television Act 1995, Consumer Protection Act 1986, Advertising Standards Council, Other Tobacco Products Prohibition of Advertisement and Regulation of Trade, Commerce, Production, Supply and Distribution Act of 2003. The answer is D. Which of the following is a challenge in regulating surrogate advertisements? Identifying the surrogate product or service, proving the intent to promote the banned product or service, ensuring compliance with regulations, all of the above. Here, all of the above is a possibility. Okay. What is the impact of surrogate advertisements on consumers? They are misled into believing that advertised product or service is harmless. They are aware of the surrogate nature of the advertisement. They are not affected by surrogate advertisements. They are more likely to purchase the advertised product or service. The answer is A. They are misled into believing that the advertised product is harmless. That is the whole goal of your surrogate advertisement. The last topic that we will be seeing for today is your Uniform Civil Code. Recently, your Prime Minister of India also advocated for your Uniform Civil Code, but also held that in place of Uniform Civil Code, it should be more of a secular civil code, which should be based on a generalistic nature rather than on a current religion based concept. Understanding? So what exactly is Uniform Civil Code means? It is application of personal laws to everyone irrespective of which religion you belong. Understanding? This is specified in your Article 44 of your Indian Constitution under your DPSP, Directive Principles of State Policy. Now, if you see, are there any uniform civil codes that are presently there in India? Goa follows a common code. We cannot call it a uniform civil code, but somewhat of a common code under the name of your Portuguese Civil Code of 1867. Uttarakhand became the first state in the country to adopt your UCC. Your 21st Law Commission of India, especially in 2018 report, have claimed that implementing of UCC at this stage is not very much necessary or very much needed. But what can be done is to make sure you reform all the family laws. Now, why did they go on to tell that yes, UCC right now is not like a need of the moment or hour? Why? Because first and foremost, there are huge complications within that. Let's say your Muslim personal laws allows for polygamy, but if you see with respect to Indian society, polygamy is not permitted. At the same point of time, see, certain things come as an exception. We said Uttarakhand is the first state. Now there is a provision where they are telling, your scheduled tribes or your tribal people will be not be affected by your UCC because they have a unique set of culture that they have to follow. Your other minority religions have opposed to this UCC, telling that it is particularly targeting our community, it is targeting our cultural belief systems. So for this, keeping all this in mind, your law commission is telling first and foremost, make sure that you reform the family laws of all your major religions rather than bringing in a UCC right now at the present moment. They are not against UCC. UCC is a good concept. That is what your Article 44 tells that. Yes, but again, there is a particular time and need. But if you see the positives of your UCC, they're telling, say, now we are on a very modern landscape. We have to adopt to our environment. We have to change to the society. Now we have to change to the societal needs. So there are multiple advantages with respect to your UCC also. So let's see some Supreme Court judgments on UCC in Ahmed Khan versus Shah Banu Begum, where they held the gender justice and the need for uniformity in personal laws. Again, like with any topic, UCC is also one such widely debated topic which has its own set of pros and it has a wide amount of. Again, UCC is one such topic which is widely debated and it has its own set of pros and cons. Sarla Mudgal versus Union of India, another case where reforming personal laws to prevent the misuse. This is also reflected in your Lily Thomas case. Shaira Banu versus Union of India case where they set aside the concept of triple talaq. Let's look at some questions. What is the Uniform Civil Code as mentioned in the Indian Constitution? A code that governs the personal laws of all citizens, a code that governs the criminal laws of all citizens, a code that governs all the civil laws, a code that governs all the commercial laws. The answer is a code that governs the personal laws of all the citizens. Understanding? So it is a uniform personal law, irrespective of your religion. Which article of Indian Constitution directs the state to secure a uniform civil code for all its citizens? Article 14, 15, 21, 44. The answer is 44. This is a DPSP. Rest all are your FRs. That is your fundamental rights. It is not yet a fundamental right. It is still in a DPSP stage. What is the main objective of Uniform Civil Code? To promote national integration, to protect the rights of minorities, to ensure gender equality, to simplify the legal system. The answer here is to promote national integration. But at the same point of time, few of the cons they are telling it affects federalism, but at the same point of time, they know it strengthens the federalism. Like we said, pros and cons are equally there. Which of the following is a challenge in implementing uniform civil code? Resistance from religious groups, difficulty in defining a uniform code, limited resources for implementation, all of the above. See here, the answer will be, for this, I want you to comment the answer in the comment section below. All right. Which of the following is a benefit of Uniform Civil Code? Promotes gender equality, simplifies the legal system, promotes national integration, all of the above. The answer here is again all of the above. What is the role of Law Commission of India in relation to Uniform Civil Code? To draft this Uniform Civil Code, to revive and revise Uniform Civil Code, to provide recommendations of Uniform Civil Code, to implement Uniform Civil Code. The answer is to provide recommendations on the Uniform Civil Code. How does the Uniform Civil Code relate to the concept of secularism in India? It promotes secularism by separating religion from law. It undermines secularism by imposing a uniform code. It has no relation to secularism. It promotes secularism by protecting minority rights. The correct answer is it promotes secularism by separating religion from law. Okay. That's it. We've reached the end of the content. If you like our content, subscribe to our channel, hit the like button and share it along with your friends. Thank you.